7 MPs switch sides. A party collapses in the Rajya Sabha overnight. And law meant to stop defections appears to have enabled one. So what really happened when Raghav Chadha and 6 other MPs walked out of the Aam Aadmi Party and aligned with the BJP? And was the Rajya Sabha Chairman right to accept it? Let me explain. We're celebrating Press Freedom Month in May, and press freedom is all about you. It ensures that you know what's happening all around you. It helps you make informed choices about your life, and it gives you the information you need to vote responsibly. Independent journalism can exist only if it is supported. And with one subscription, you help not one, but 2 organizations that cover 2 different regions stay afloat: the News Minute and News Laundry. So what's stopping you? Become a subscriber or support my show by contributing directly. On April 27, 2026, Rajya Sabha Chairman C.P. Radhakrishnan formally recognized that Raghav Chadha and 6 other MPs had left AAP and joined the BJP. AAP's strength dropped from 10 MPs to just 3. The BJP and the NDA moved closer to a working majority in the Rajya Sabha. AAP challenged the move. Senior leader Sanjay Singh petitioned the chairman seeking disqualification of the 7 MPs and calling the move unconstitutional. AAP accused Chadha of betrayal. He responded by calling the party's internal work culture toxic and its ideals compromised. Well, that's all politics. Was Raghav Chadha's move legal? The anti-defection law in the 10th schedule of the Constitution was meant to stop exactly this kind of party switching. It lays out when a legislator can be disqualified. If an MP voluntarily gives up membership of the party, they can lose their seat. On the face of it, that should apply here. 7 MPs clearly left their party, but there is a loophole, or depending on how you see it, an exception. Paragraph 4 introduces the merger clause. It says disqualification does not apply if 2/3 of the party's legislators agree to merge with another party. AAP had 10 MPs, 7 left together, and that crosses the 2/3 mark. Now, the MPs argue that this qualifies as a merger and that protects them from disqualification. The chairman accepted that argument. Legally, the decision follows the text of the Constitution. But that's exactly where the controversy begins. The key question is this: is Raghav Chadha and 6 MPs leaving AAP to join BJP really a merger? Senior Supreme Court lawyer and Rajya Sabha MP Kapil Sibal says no. His argument is simple. For a merger to be valid, the parties must merge first. Only then the legislators can jump ship. Here, that didn't happen. AAP did not merge with the BJP. Only a group of its MPs switched sides. So in his view, this is not a merger. It's a coordinated defection. Other experts have taken a more cautious view. Former Lok Sabha Secretary General TDP Achari says MPs appear to have voluntarily given up party membership, which would normally lead to disqualification. But he also points out that the merger clause offers them a possible shield. He also underlines a basic point. The law was meant to prevent defections and not facilitate them. This is the law's central tension. It once allowed splits. 1/3 of legislators could break away without disqualification. This clause was widely abused. So in 2003, Parliament removed that provision. But it kept the merger clause, raising the threshold to 2/3. The assumption was simple. A higher number would make manipulation harder. But this case suggests otherwise. If enough legislators act together, even 2/3 mark can be met. And once it is, ironically, the law offers full protection. The result is a paradox. Individual defections are punished, large organized ones survive. We've seen versions of this happen before. In 2019, in Telangana, Congress MLAs crossed over to BRS after hitting the 2/3 mark. In Parliament, TDP MPs did the same and went to the BJP. In all these instances, courts have been reluctant to intervene without clear evidence of illegality. The Aam Aadmi Party calls this a constitutional fraud. The MPs insist they acted within the constitution. Which brings us back to the House Chairman. Under the 10th schedule, the chairman decides disqualification. But the Supreme Court has made it clear that these decisions can be reviewed. So this may not end just here. So was the chairman wrong? If you go strictly by the law, probably not. The numbers do add up. But if you look at the spirit of the law, the answer is far less clear. And that raises a larger question. Does the law itself need reform? Because the case exposes its weakness. The law focuses on numbers and not the intent, and it does not ask why legislators defect, only whether they meet a threshold. It also weakens the link between voters and representatives. Because voters choose candidates based on party affiliation. But that affiliation can change without the consent of the voter. Now imagine you voted for an MP because they stood against something. Let's say like communalism. And then they switched overnight. This isn't just about one leader or one party. It reveals a deeper contradiction. A law meant to prevent defections may now be enabling them. A safeguard against instability may be facilitating strategic political shifts. The real question isn't just whether the law was followed, it's whether the law itself is working.